Can a community spouse challenge the minimum monthly maintenance needs allowance based upon the high cost of living on Long Island? To find out, you have to read Matter of Balzarini versus Suffolk County DSS, but it's 6 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases and I try to do it in 5 minutes or less. But this is part of a special limited series I'm doing on cases relevant to the elder law and estate planning community. This is the important case of Matter of Balzarini versus Suffolk County DSS, published by the New York Court of Appeals on February 15th of 2011. The citation for this case is 16 New York 3rd 135, and the issue in this case is, can the community spouse seek an increase in the minimum monthly maintenance needs allowance based upon high living expenses on Long Island? This is an important case. It's kind of a complicated case. It's a bit of a challenge to try to do this in as close to 5 minutes as possible. I'm going to try my best. Here they go. The background that I think is helpful to understand this case is that Medicaid and Medicare are statutes that are passed by the federal government that allow a person who needs care but can't pay for the care to receive it, partially getting subsidized for that care by the taxpayer. In the MCCA, which is the Medicare Catastrophic Coverage Act, one of the laws passed by Congress in Washington, D.C., to craft the legislation here, they had to balance the care given to the institutionalized spouse, which is the person in the nursing home or the assisted living, versus the community spouse who would otherwise get dragged down to the ground like an anchor because of the high cost of care. So one of the things that the MCCA did, that Medicare statute legislation, what it did is it created an MMMNA. I call it the triple MNA, the minimum monthly maintenance needs allowance. And it basically is a floor that Congress set at 150% of 1/12 of the federal official poverty line. So it's a line they drew saying, this is what we think the minimum amount of money that a community spouse needs to survive is. And if the community spouse, the one who's not in the facility, the one who's home, makes more than that line, they don't get any of the money of the institutionalized spouse. If they make less than that line, then some of the institutionalized spouse's income can get diverted to the community spouse. So that's the situation. But there's a specific rule in Social Services Law 366C that allows a community spouse to say, I know I make more than that floor of the MMMNA, okay? But I think should get more money than the MMMNA line because there's a special, extraordinary, exceptional circumstance that's creating financial duress that is out of my control, okay? It's got to be something like, a meteorite falls from the sky and breaks the roof. That would be an extraordinary, unforeseen event that creates financial distress on the community spouse. And for that reason, they can ask for an increase of what the line is, okay, to get some income from the institutionalized spouse. So what are the facts of this case, now that we've laid out a little bit of the background? This case takes place in 2005, and there's a husband and wife here, John and Frances Balzarini. They live in Suffolk County, New York. And John has to go to a nursing home. They each have an income, each of them from Social Security and a pension. And John applies for Medicaid because he goes to a nursing home that costs $6,800 a month, which is more than he makes. He makes $2,378 a month. So what's going to make the difference between the amount he makes, that $2,378, and the $6,800 it costs to live in the facility? The answer is Medicaid, okay, the taxpayer. So he applies for Medicaid after Frances, his wife, does a spousal refusal, basically saying, I'm not providing any money for him. At that point, he becomes immediately Medicaid eligible. So Medicaid calculates how much of his money has to go to the facility, and they calculate basically all of it has to go to the facility. And they're going to make up the difference between his income and the $6,800 it costs to live there. That's great. He's getting treated, and he doesn't have to pay the entire cost of the care. But then remember, there's a community spouse in the community. Frances is still living at home. And she only has an income of $2,444 that has to cover her for everything. Has to cover the condo, the gas, the car, the homeowner's insurance, taxes in Suffolk County, Long Island. So she and he file an application to increase the triple MNA. They say she's under financial duress. She can't live as she's been living based upon this amount of money. She needs to get some of the money diverted from John's income. DSS calculates the amount of money that she's entitled to, and they say nothing. Her income is higher than the MMMNA. So she's not entitled to any of that income being diverted from John. And they say this is not an extraordinary circumstance. So they appeal. John and Frances appeal, bring an Article 78 to challenge the determination. It goes to the appellate division, and the appellate division says, you're right. This is basic living expenses. She can't live as she's been living in Long Island. John, DSS is wrong. They should send her some of this money. It goes to the Court of Appeals, and they reverse. They say the problem here is that Frances's expenses are the basic expenses that the MMMNA are designed by Congress to address. They say the wife is seeking an award to pay for everyday living expenses, but Congress created the MMMNA precisely to cover that kind of ordinary and non-exceptional expenses. They determined in Washington what the floor is. And even though in Long Island and Suffolk County, that's not a good floor, that's not enough to live the way you've been living, they say that's not the goal of Medicaid. The goal is not to provide taxpayer money to allow the community spouse to keep the same quality of living, the same level of life and expenses that they previously had. The spousal impoverishment provisions are not meant to allow the community spouse to keep the prior lifestyle and have the public subsidize it. There's no guarantee to the community spouse to have the same standard of living. So they say the trade-off is that the institutionalized spouse gets the care, but at the same time, the community spouse does not get a guarantee to not lose her quality of living, her quality of care in the community. So the ultimate holding is this is not sufficient grounds to raise the level of the MMMNA. It's not exceptional, and it's already accounted for by the MMMNA determination of Congress. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.